We are led by learned advocate general.
Yes.
We are led by learned advocate general in court number 17. Item 23. I'll come back. He is requested to convey to your lordship that either 12:30 or 2 p.m. or 12. My lord.
Well, let them come back at
12:30.
let them come back with the order passed under 163. Essentially, a 144 order which they are citing,
Yes.
but 144
Whatever.
cannot be
Where is the order
not published
under 163 BNSS?
We shall come with the order. Let it be. Let anti-reporting comes. At 12:30 your lordship.
They have
We
stopped,
shall produce everything.
they have stopped publishing the
No,
order.
no.
At 12:10. Come back at 12:10.
Order
Oblige. How far here?
here known as Mohistola, which is just at the edge of where the jurisdiction of Calcutta Police ends and the Diamond Harbour Police District begins. So the unfortunate incident, my lord, it had, but this what I am submitting is, my lord, pursuant to the press conference which was held on behalf of the police administration. It had taken a communal flavor. Now the police has come up with a press conference stating that there are arrests which have been made. Now, the temple was vandalized, people were injured, and accordingly, my lord, an application.
When this incident took place?
This had taken place, my lord, on last Thursday.
Date?
11th of June 2025.
My lord, we had, my lord, written to the SP of the concerned police district, stating that, my lord, the petitioner number 1, it is at page 46, my lord. The petitioner number 1, who is a member of Legislative Assembly, my lord, from the opposition and happens to be the leader of the opposition, along with one more MLA, my lord, from the opposition, my lord, they will be visiting the area to meet the victims, my lord. So this application was made on the 11th of June. Page
46 is the application.
My lord.
Yes.
Page 54 is the response. The SP responds by saying that as per information received, Honorable Leader of Opposition is going to visit Mohistola and Rabindranagar area on 12/6 at 2 p.m. This is to bring to your kind notice that under section 163 BNS has been already promulgated to the entire Rabindranagar PS area jurisdiction. It is requested that for maintaining peace and tranquility, please postpone today's visit at Rabindranagar and Mohistola area. You may kindly fix up another date after revocation of 163 BNS Rabindranagar PS jurisdiction.
Now, whether the 163 BNS order is still claimed?
Till today.
Till today.
But nowadays, my lord, but an order has to be promulgated. The SP also has rightly said that it's promulgated. It is never published, my lord. What is available is, my lord, this, my lord, from the Twitter handle, my lord, of the West Bengal Police. It's just a tweet. যদি শেষ হয়ে যায় আজকে তাহলে
মামলা করিস কেন মামলা করার জন্য মামলা করে না দেখে রিসার্চ না করে মামলা করিস কেন?
অর্ডার দেবে
মামলাটা নম্বর কত?
5
এইটা দাদা
5 নাম্বার এই তো এইখানে উপর লেখা আছে।
না ওর লিস্টটা দেখে
না তোমার সামনে আছে রিপোর্ট।
নেই তোমাকে দেওয়া হবে মামলা করো কি ডকুমেন্ট পাওয়াচ্ছ না দেবো পরশু দিন দেবো।
So it is up to 16th of June, Mr. Doctor.
Yes.
So today is 16th.
Today is 16. Kindly look into the
and what are the conditions mentioned in the order dated 13 June 2025?
ABC. Yes. আমাকে আরেকটা কপি দাও।
Give a copy to advocate.
I have it. Yes.
We do not have copies, Baral.
No, why will I supply a copy? There is a tendency with respect. Yes.
Now the conditions, the 3 conditions are assembly of 5 or more persons, excluding persons on official duty.
Right.
Then carrying on firearms, stick, stones, weapons, etc.
Yes.
Then any type of procession rally.
Yes.
Now these are the conditions, and these conditions are claimed till 16 June. Today is 16 June.
Right.
Now if the petitioner along with another MLA want to go for interaction with the local persons
Yes,
without organizing any procession or rally,
yes.
then where is the difficulty?
But the first objection is, my lord, how does the leader of the opposition, he considers him to be a very big person, very well, let him consider him to be so, will have this unequivocal right, wherever some incident happens, then all his compassions rise and he has to go there. He will not go over there after another incident happens. Sondeshkali, whenever 144 he comes to court, the court gives him liberty. He goes over there, calls a police officer.
The state cannot go
No,
beyond
no, no, no.
what
No,
is
no.
on record. Page
No.
54,
Therefore, Milord, please take this case. Please entertain this case. Whether, Milord, and on the promulgation of or on an issuance of, Milord, a 144 order, a
Promulgation is also invalid.
163,
It is not
whether,
published.
Milord, somebody can maintain a repetition. Because the remedy is in the section itself. Please have a look to
But I
163.
have also annexed my lord similar.
Please have a look to it,
not the
163.
first instance.
Yes. Kindly decide this point.
The point has been decided adequately by.
Please, Milord, on this angle, Milord, kindly.
Division by
Yes.
Following Anuradha Basin.
Yes.
Yes. Paragraph 141, 142.
Yes.
Grateful.
Yes. Before that, Milord, please take Milord, what are the prayers? Please have a look to the prayers.
No, but the first thing is this, Mr. Dotto.
Yes.
This order is up to 16th of June. Today
Yes,
is
he
16th
was.
of June. If court permits the petitioner, two petitioners, to visit the area tomorrow,
Yes.
then this order is not there.
Point is, Milord, somebody cannot come to the court, Milord, in the vacuum.
No. It has been
Milord,
responded to by order dated 46.
Yes.
At page 46.
Yes.
So there is no vacuum. You have already made your
Milord,
stand very clear.
Milord, if he is aggrieved by the order of, Milord, of the communication, which is at page 54, Milord, please take Milord, page 54.
Yes.
Kindly see the last sentence. You may kindly fix up another date after revocation. So let him say that I want to go on day after tomorrow or whichever date. Why is the court's intervention required?
No. Prayer is made since an order, request was made by the petitioners to visit the place. When referring to section, an order under 163 BNSS Robindranagar, this 163 BNSS, the prayer of the petitioner has been turned down.
Very well.
Now, subsequently, today a writ petition has been filed praying for permission so that the petitioners can visit the place and interact with the local people. Now, at today, it appears that the contention of the petitioner is found to be correct, that there was an order passed under 163 BNSS.
We have
Now, in 163 order, it is up to 16th of June.
Right.
5 persons, my lord. 5 or more.
Right,
Yes.
I do not accommodate myself within that.
First is, Milord, if this order.
I am appealing to the DSP.
You are
Everything of police.
yes.
I will make
Respond number 2.
Respond number 2.
Yes.
Maintainability of the petition itself is a
Well, please take the section. Please take the section. If, Milord, a 144 or 163, if it is issued, well, the remedy is, he may be aggrieved by the 163 order. Definitely he can be aggrieved. Well, the Lakshya has found, Milord, from
163, yes.
yes, 163, kindly have a look to 2.
Just a minute.
Yes. Or I'll read the entire section. Can you have a look to the entire section? In cases where, in the opinion of the district magistrate, a subdivisional magistrate, or any other executive magistrate is especially empowered by the state government, in this behalf, there is sufficient ground for proceeding under this section, and immediate prevention or speedy remedy is desirable. Such magistrate may, by written order stating the material facts of the case and served in the manner provided in by section 153, direct any person to abstain from a certain act or to do certain orders with respect to certain property in his possession or under his management, if such magistrate considers that such direction is likely to prevent or tends to prevent obstruction, annoyance, or injury to any person lawfully employed, or danger to human life, health, or safety, or any disturbance of the public tranquility or the right or any affairs. An order under this section may, in cases of emergency or in cases where the circumstances do not admit of the serving of due time of a notice upon the person against whom the order is directed, be passed ex parte. The order under this section may be directed to a particular individual or to persons.
Yes, so this is an order, Mr. Dotto, you are submitting in terms of 163(2).
Yes.
So it is ex parte order in case of in view of emergency.
Right.
Now this ex parte order is subsisting till 16th.
Well, may I just complete this section? Then my lord, kindly see, my lord, how to whom it can be directed, that is under subsection C. It can be to against an individual or to persons in an area, place, or to the public generally when frequenting or visiting a particular place or area. No order under subsection 4, no order under this section shall remain in force for more than 2 months from making thereof, provided that it is state government considers it necessary so to do for preventing danger to human life, so and so, so and
That is relating to extension of
extension.
beyond.
Now please take 5. Any magistrate may, either on his own motion or on the application of any person aggrieved, resigned or alter any order made under this section by himself or any magistrate subordinate to him or by his predecessor in office. And 6 is, the state government may either on its own motion or on the application of any person aggrieved, resigned or alter any order made by it under the proviso to subsection 4. So this is the extension part. Then 7, when an application under subsection 5 or subsection 6 is received, the magistrate or the state government, as the case may be, shall afford the applicant an early opportunity of appearing before him or it, either in person or by an advocate, and showing cause against the order. And if the magistrate or the state government, as the case may be, rejects the application wholly or in part, he or it shall record in writing the reasons for doing so. Therefore, my lord, if my learned friend is aggrieved by the 163 order, my lord, the remedy is in the statute itself. Remedy cannot be made by way of a writ petition. So, my lord, if he says that 164 is preventing my fundamental right, which is ordinarily said. Now, if it prevents it,
But Mr. Dokto, in similar cases, our single benches, division benches passed order.
yes.
So
My lord, in similar cases, my lord, your lordship kindly
identical issue has been considered and order has been passed.
yes. But my lord, please consider, my lord, whether this point has
If today
Yes.
court directs, permits the petitioner, 2 petitioners along with their security personnel to go the place and interact,
Yes.
then how you are prejudiced?
No, it's not a question of prejudice. It is a question of, my lord, crossing the threshold limit. Whether, my lord, this kind of a writ petition your lordships would entertain or not, my lord, despite the remedy being under the statute and the section itself, my lord, please consider this. Because otherwise, my lord, the court will be burdened with all this. My lord, I have a right to go anywhere I like.
Yes,
I have a right.
that is 19(1)(d).
Yes. Now, my lord, if I have a right, whether, my lord, this right is completely, my lord, an unfettered right, or, my lord, this right is subject to reasonable restrictions or not. My lord, Article 19 itself, my lord, provides that, my lord, there can be reasonable restriction to this right. And, my lord, the courts have held that 144 or now 163 is one of those reasonable restrictions. But otherwise, what will happen?
Yes,
But any order under 144 or any order under 163 is susceptible to, my lord, affect any or a single person's right. But your lordship cannot come across any order under 144 or 163 which does not affect anybody's right. And the right that is sought to be projected to be affected is the right of free movement. Now, if the right of free movement is always ensured, my lord, divorce the, my lord, object of the statute, then, my lord, it would be very difficult for the administration also to function. But the administration has not denied. The administration says that, okay, fix another day. It is not a case of denial, or it is not a case of obstruction of somebody's fundamental right to move in any direction. So, my lord,
now Mr. Bhattacharya, do you want to bring on record this?
Can I make-
Yes, I will hear. Do you want to bring on record this order?
But the order has not been
No,
promulgated.
no, I will direct them to supply a copy of the order. Because this is not part of the writ petition.
not part
You
of
have
the-
mentioned this order in
Yeah,
your writ
because
petition.
we have gathered our knowledge from
Yes.
the and
oh,
we
yeah,
have communicated.
54,
Because
54.
today,
Oh, JK
Mr.
Chaitanya
Dokto is
Shetty
inviting
said-
this court to consider the merit of this order, the validity of this order.
We may consider the merit, my lord, even without looking at the order, my lord. I think, my lord, I'll be having a reasonable reply, my lord. I'll wait for my esteemed senior friend also, my lord, to advance his arguments. I'll be dealing.
So it is not necessary to bring on record this copy of the order question
The
by
order,
way of a supplementary
the
video.
order is applicable, my lord, in respect of an assembly of 5 or more persons. My case is, my lord, I do not come within the ambit of that particular order, but the SP has acted ultra vires the provisions of not only the Constitution of India, as well as ultra vires, my lord, the provisions of this particular order, because he is attempting to apply an order which is not admittedly applicable to us, to 2 persons. That is my case, my lord. I squarely come within para 15 of my lord, Whirlpool case, my lord. That is the 1998 volume 8 Supreme Court cases, page 1.
Can I meet?
Please consider one line reply. One line reply is whether, my lord, Whirlpool's case would apply in a case where there is a parallel law which permits reasonable restriction to be applied.
That's an only alternative.
Where there is only alternative remedy except that nothing is there, here, my lord, it is a reasonable restriction. The Supreme Court has, Miller, considered these points and has said that an order under 144 is a reasonable restriction. Quay the right of free movement.
But one thing, Mr. Dotto, this order which has been passed on 16 March 2025, it says that assembly of 5
Yes.
and then carrying of firearms, then any type of processions.
He has no
If these
cause of
things,
action.
if these things,
Then
if
he
these
has no
things,
cause of action.
if these things are complied with,
Yes.
and the petitioners are permitted to visit and interact, then what is it?
No, why
Within
the
the
court-
parameters,
no, can-
within the
can I just-
parameters,
can-
yes,
can I just
within the
say-
parameters laid
I-
down
I
by
will-
the,
I'll address
laid down in the order.
No, I will address why the court blessings is required. Why the court blessings is required?
Because
No, nothing.
no.
Come to
police
prayer.
authority has refused the prayer
No,
of the petitioner.
no. Why he will make the prayer?
Why not?
Why? No. If 163 is there,
Why
no,
not?
no. The question doesn't come to his prayer. He is aware about 163 order. Come to the prayer first, page 34.
Yes, he has not.
My lord, this is a weapon for just publicity. If you think that I will go with 2 persons, you don't need a permission. Why you have written this letter? If you have an honest intention,
No, sir.
my lord, kindly just
Yes.
one by one. Kindly do not jump into the last. Let us go from the step by step. First, kindly come to page 47. Where is under which law it is required? Why you have sent it? You are coming up before a high court under Article 26 for enforcement of your right. It's a mandamus. Under which law? Under which law? Why the high court will interfere? If 5 up to 5 is permitted, you can go. So why the court's blessing is required?
Please come to page 54.
I am coming. First is page 47. These are
Since you are
Since
you are
simply
you are
because not simply because you have
submission that why it is required.
no simply because he has written the letter.
Why it is required? Because it is required in view of the page at page 54.
What? No. Page 47 is not before page 54.
No,
Page
no,
47 is my lord, page 47 is first or not?
Yes, this is an application page.
Why? Under what law? It's a mandamus. Enforcement of legal right. What is that law? And you are aware about the fact that 144 is there. I mean, now the 163. His prayer is itself is this. Well, that every time a political leader will take the court blessings and go to the public because of the court I have come here. This is also not permissible. My lord, kindly do not allow this forum to be utilized politically. If it is not required, your lordships have correctly observed. He can go, 2 persons will go. What is the difficulty? There is no difficulty. Until he does any illegalities, if he commits any illegalities, we will take steps.
No, we cannot take.
And we cannot take steps because of the High Court's blessings.
No, if I-
No FIR can be lodged against him anywhere. High Court has passed an order, and 3 years this is there. He will go, he will do everything, he will activate criminal activities, he will get slogan, he will do everything. He can file any cases, 1,000 cases, but against him, not a single case is allowed. High Court blessing is there.
Yes.
Therefore, he was not required to. My lord, why the Reed Court? Why I am arguing, I tell you, lords. Why the Reed Court will exercise the power? If 16th is last, it has become infractuous. For tomorrow, your lordship is not required to pass an order unless 163 order is passed face. Why your lordship will give the blessings to him? Is he a Superman?
No, to ensure the right guaranteed under
No, to ensure means
part 3
my lord, kindly now where is this? Where is right has been infringed? My lord, your lordship, my lord, your lordship,
in a legislative assembly is being prevented to go to a particular place.
where he has been
Happened to
where he has been
common
prevented.
people.
My lord, where he has been prevented. My lord, a leader of opposition does not enjoy any extra status other than
That is the
the
spirit
my
of
lord,
democracy.
kindly. My lord, that is the incorrect impression are being carried by few judges of this court. Leader of the opposition are not privileged persons beyond the assembly.
Don't
My lord,
make-
sorry.
Don't make aspersions against any judges.
No, it's all right. My lord, all the time.
Not accept very.
No, that's all right. If you may not like me, that doesn't matter. But leader of the opposition is not God. Every time your lordship court is saying, where is it?
Today, if the order passed in terms of 163 BNSS does not make any prohibition for visiting the petitioner petitioners to a particular place,
If
as it appears,
my lord,
then why you are
no, why he has made,
or why you are
I
making an argument in order to prevent?
I cannot understand, my lord. I am sorry. Kindly excuse me. Your lordships will take the exception. Unfortunately.
No.
No, unfortunately, your lordships will take the exception.
What I am just
No, your lordships,
Your submission-
your lordships, no, that is it. This is being done. Kindly do not indulge anything from this institution for giving a political thought, which is going on.
yes.
Unfortunately, it is there.
No, but
Now, my lord, first, let us come to the law. Let us come
I am
to,
asking you.
my lord, let us come to the law.
The order, yes.
Will your
If it
lordships,
is required, then the order.
my lord, unfortunately, I could not make myself clear.
No, yes. Very
I am
much clear,
very
Mr.
sorry.
Bandyopadhyay.
I am
You
very dull-headed.
you are
man, my lord.
seasoned
I
advocate.
am not
You
intelligent.
are arguing for last 10 minutes. You have made your client stand absolutely clear.
Absolutely not clear.
Now
But
the
still,
thing
your
is,
lordship is asking the questions. Therefore, I am not making my lord.
the order
First question.
passed under 163 BNSS does not make any prohibition. So far, the visitation of the petitioner is concerned
Yes.
to that particular locale.
Yes.
Then why you are arguing this matter?
No, I am not. Why he has made this application?
Because in view of the previous order.
What is
Now-
previous orders?
Now there was an order passed by under section 163 BNSS. That order was not part of the writ petition. Now it has been rightly stated in the writ petition that order has been passed under section 163. Now 163 order has been.
Then in that case, your lordships have to take it.
London-
In that case, your lordships can give time. In that case, we will show the division bench order. He was not allowed to enter.
Very well.
Yes, please, Mr. Biladal Bhattacharya, Mr. Biladal Bhattacharya, have your patience. You have come up with your all friends, central government agency in such a matter. You have come up with all, served everyone. We know about what is the modus operandi. We know about all this. Now, no, go. Why the court blessing? Why the court blessing is required? My point is, will you allow, or Mr. Bhattacharya, I will not allow you to make submissions if you go on continuing this until I finish it. And what will happen when we will be elevated as a judge? At least don't sit in Calcutta High Court. Fully political we would be. Yes.
I think that
No,
this discussion can be carried on at the corridor.
No, there's any discussion can be carried on.
Yes.
Any discussion can be.
Yes.
Milord,
Yes, Mr. Bandyopadhyay.
first, Milord, 163 does not. 163 anyone can go. All right. Subject to the condition up to 5. There, he didn't make the application. Who has made the application? What he is trying to do? What he is trying to do? Request to allow Sri Subhendu Adhikari, Honorable Leader of Opposition, West Bengal list along with one MLA and their central security personnel to visit Mohestola under Rabindranagar police station. As per the directions of I-1, will be
Well, I am directing the petitioner to make an application in course of this day and allow him tomorrow.
Why the application is needed? I don't understand that.
Allow him tomorrow. Because apparently there is no restrictions in the order dated 13 June 2025 if less than 5 persons go there.
Yes, no. Then in that,
Within the parameter,
Milord, in that case,
within the parameter
I'm
of-
sorry, my lord.
within the
In
parameter
in
of
that
the-
case,
please allow this court to express its mind also. Within the parameter of the order dated 13 June 2025 issued by the subdivision magistrate, I will permit them to go within the parameter.
can I make submission? Then?
Yes.
Therefore, Milord, your lordships wants to give him blessings.
No. Why-
That's
why
right.
should I?
Political blessings. It will be.
Not a political.
No, naturally.
Cannot-
Why the High Court will entertain a petition?
No.
No, High Court will entertain a petition. Why the High Court will entertain a petition when 16th is there, 16th is last? Why
Yes.
your lordships want to give the blessings?
No,
That
it's
would
not
be
a
for
question
the.
of giving
No, that's right. It's a blessing.
Mr. Bandyopadhyay,
It's a blessing.
application was made. This was turned down by the concerned.
Not turned down.
In reference to 163 order. Now 163 order has been placed before this court. On perusal of 163 order, it appears that within the parameters, issue can be sorted out. And since the prayer of the petitioner at first was not allowed, permit him to visit the place in order to give sanctity of the constitutional right which every citizen enjoys.
No, I do not understand why lordship is perceiving that we are destroying the constitutional right.
Being a
These are
judiciary
unfortunately-
and constitutional court,
No.
court considers this from the angle of Article 90.
Just right. Milord, we are in your lordship is a constitutional court, but we are also, Milord, know something about the constitutional law. Unfortunately, I know something little about the constitutional law. And your lordship is the constitutional guardian.
Yes.
I know that your lordship's knowledge is far better than me in the constitution. That is no problem of that. Question is whether the court will pass an order when there is no cause of action.
Because cause of action is there.
Nothing.
What Mr. Bandyopadhyay
Nothing.
is submitting in this
Nothing.
is the page 54. Page
Why the page
page
16?
Yes.
No, page after 16 there is nothing. No order is there.
Page 54 order is there
Page-
by your superintendent of police.
Superintendent of police passed an order on the basis of his application. Was the application was warranted?
No, application was
My
not
lord, whatever I am submitting, your lordship is saying no. Whatever he is submitting, your lordship is yes.
said anything.
So very nice. I am so grateful. Pass your order. But today my impression is something that so far state of West Bengal is concerned in such a matter, your lordship will say no, your lordship will say yes to Subhendu Adhikari. You may take exception to my knowledge. This is not correct that when this is the reason I do not decide. My lord, do not, if this is said, if this is said, if this is said, I will file an affidavit. There is no communal violation. Come to this.
Well, I keep this matter pending.
Yes.
File your affidavit.
Yes,
Submit a report.
Yes.
And in the meantime, permit it.
if he is
How you are prejudiced, Mr. Bandowat?
no, that's all right.
Because not in violation of the order passed in one.
But I do not understand. No, I am not prejudiced. Why your lordship is giving a handle to a thing which is not
No, it's not a
your
question of
lordship
giving
is-
handle.
No, 60. Why is it? I would have thought that your lordship asked the question why you have made this application. Why this application has been made?
But court will
Because
not,
if today,
will not
because I am
respond
a political
strictly
man.
in terms of
Pardon?
your thoughts.
Pardon? No.
Will not respond
That is then the court is very much overzealous to the state is concerned.
Yes.
Then the court is overzealous to the state is concerned. Sorry. If court thinks that it will be happen, then court is overzealous to the state is concerned. I'm very sorry.
That if that.
My lord, I will also kindly
This is
see.
your perception. Then
No.
you keep with this. Go on with this perception. Court is not going to mend you. It is not court's duty. What is passing through your mind, you have stated. But what I find from the
No.
report and
My lord,
completing your submission,
I do not-
I'm expressing my mind.
My lord, I do not understand. We are also political persons. We also move it. 144 is so many places. We go meet. We don't file an application. Why? If more than 5 persons we go, we file an application to the police. Allow us. And every time, whenever this application will be Subhendu Adhikaris will come, the court will entertain in a vacuum place whatever Mr. Advocate General has said, submitted. There's nothing, no cause of action. There is no cause of action.
But may I submit one thing?
Yes.
Your lordship may keep this matter pending here without.
Hmm.
Let us come back day after tomorrow. Tomorrow, if he wants to go, he may go. Kindly do not make any observation.
Well,
Kindly do not make any observation. Keep it day after.
No,
tomorrow.
I am keeping this matter pending. In the meantime, I am granting leave to the petitioner to attend the place, and I also direct the authorities to ensure that no untoward incident takes place.
No untoward incident means what? If he
Matter ends.
if he creates an untoward incident, what will be what we will do?
In that case, we need to place certain things on record. But this is a matter of record. It is in the record of the High Court. In Sandesh Khali, 144 orders were passed. The court watched the 144 orders and he needs to go. He goes over there and calls a police officer. It's on record.
my lord, that is far from the truth, my lord. The state
No,
filed
it
an
may be
application which has been withdrawn by the state.
Yes,
my
it
lord.
may be
The
untrue.
state cannot say that he called someone this and
Yes,
that.
Miller,
This is highly objectionable, my lord.
This
Had
is-
it been an
this is on
individual, had it come
on
from an
record.
individual, my lord, it was
But
something
Mr.
different.
Bhatt, it is not a case where court is required to go into the niceties of the order passed under 163.
Yes.
Because within the parameters as contained in the order under section 163, petitioner can be permitted. Let him go visit and come back.
The problem is,
Visit
there are
and come
various
back.
laws. Number one is, the court cannot control his activities. Number one. Number two, if his activities are beyond what is required, we cannot take any action. Because we cannot lodge any FIR. Number three, hate speeches this person gives everywhere. Every day,
We cannot raise.
we cannot take any action. These are the impediments. Number four,
These are, my lord, wild allegations, my lord. There is not a single contempt application, my lord. Not a single contempt. This, my lord, is the submission, the common submission in each and every case. I have to knock the doors of justice, my lord, in each and every case. The
Okay,
latest
why
thing, my
you
lord,
No, this is also incorrect. I am contesting the matter. I have argued. One after case has been started and we have to take leave. The problem is this, only thing, this gentleman will go make hate speech, speaking about Hindu, Muslim. He will create another disturbance, but no one can start case against him. Kindly, my lord, consider if when your lordship has observed constitutional duties, discharging, restrain him not to pass any comments. Because according to him, it is a communal things have been done. And if he commits anything, give us leave to start case against him.
That how can I already he's enjoying an
No, that's the problem. That's the problem. 3 years, 4 years are going. Your lordships will say, don't blame. But what can I do? 4 years interim orders. Argued the matter in December 2023. Judgment has not yet been delivered.
Even in the recent Murshidabad riots also, my lord.
Murshidabad riot, you have tried. My lord,
I had to visit, my lord.
no, Murshidabad.
From the
No, Murshidabad riot.
riot this, my lord, at the time of Sandesh.
Murshidabad riot. No, Murshidabad riot. You are on the very first day. You didn't get any order. Tell the truth. You have asked for 355. You didn't get the order. You have passed order for the this NIA. You didn't get the order. After 1 month, 15 days, division bench presided over by Justice Sen passed an order. Only allow him 2 persons to go.
That is my prayer.
No, 10 booth. After 1 month, 15 days.
Yes.
After 1 month, 15 days. Not on the very first day. Not on the very first day.
One of the submissions. Number one, my lord, the leader of the opposition do not, my lord, enjoy any extra benefit. Because he is an MLA like all other 248 or 249.
But I have just handed over the office memorandum, my lord. I'm supplying a copy to the learned advocate general also, my lord.
No,
Which
taking
states about
cue from
leader of the
taking cue from the submission of Mr. Bandyopadhyay. Mr. Datta, please come to page 82 of the order passed by the Honorable Division Bench in Murshidabad matter.
Yes, yes.
When?
Yes,
Page 82.
yes.
Yes, second line, petitioner number 1 and 2 may interact with the victims at the aforesaid 3 places. However, they shall not take out any procession and hold any rally and make any public speech that are likely to cause
My
breach
lord
of-
imposes similar conditions on him, my lord. I am inviting this, my lord. Yes.
Then the anxiety of Mr. Bandyopadhyay, which is being expressed on behalf of his client, can be taken care of.
But this order, your lordship passed me, lord. But this order was passed after 1 year, 1 month, 15 days of the incident.
Well, the incident of riot, my lord.
Mr. Bhatia, will you allow? Only you are the lawyer. Every time you will be speaking. What is this?
My lord,
Every time you will say, you are misleading the court every time. Can you see the order, date of the order? No, what is this? Every time.
Please come down. You have to address this court.
12th of April, my lord, the incident took
Please
place.
come down.
23rd of
Here,
April.
allow Mr. Bandyopadhyay to make submission.
Kindly see the order, 23rd April 2025.
Yes.
When
The
the
contention is this was-
incident had taken
on the
place
first
long
occasion.
back.
This was not passed on the first occasion.
First
After
occasion.
sometime after a period of 1 month, this order was.
My lord, I tell you, lord.
Now, I take
tell you, Lord.
advantage of your presence and presence of Mr. Datta, where the order under section 163 BNS is passed. Parameters has been set up. Within the same parameters, if this can be done and accepting your anxiety and agony, where is the difficult?
No difficult.
Yes.
No difficult. But from tomorrow, not today.
No. 2 more.
Only 1 day.
Yes. Only 1 day. I'm accepting your content.
And my lord, I have handed the my lord, the office memorandum, my lord. So your lordship, my lord,
nothing.
indicating, my lord, the
And also the press conference, my
the
lord.
back, my lord, press conference beyond the area, my lord.
Take on an order.
On that area,
Matter
in that
matter
area.
is heard at length in
Well, the leader of the opposition
presence
enjoys
of
the
the
status of a
learned
cabinet minister, my lord.
advocate,
I have handed that over.
representing the petitioner, state respondent. Mr. Bandyopadhyay, you are appearing for?
I am appearing for respondent number 225. Police.
Representing the learned advocate, representing the petitioner, comma, Mr. Kishore Datta, learned advocate general, yes, representing the state respondents, and Mr. Kullan Bandyopadhyay, learned senior advocate, representing respondent number 3 and 4, 2 to 5, representing respondent number 2 to 5. Next paragraph. On perusal of the writ petition and the case made out, it appears that member of the opposition, it appears that leader of opposition of West Bengal Legislative Assembly, along with another member of Legislative Assembly, have approached this court with the present writ petition, comma, inter alia praying for a direction upon the concerned police authorities to ensure safety and security of the petitioners while petitioners will visit a local called Mohestala, or when petitioners will visit Mohestala in order to interact with local persons after an incident.
This is under the jurisdiction of Rabindranagar Police.
After an incident which took place on 11th of June 2025. Next paragraph. An application on behalf of the petitioner number 1, was made to the Superintendent of Police, Diamond Harbour Police District, on 11th June 2025, as it appears from page 46 of the writ petition, requesting the police authority to make arrangements which would permit the petitioner to visit the aforesaid place. Stop. In response to such application, a letter was issued by the Superintendent of Police, Diamond Harbour Police District, on 12 June 2025, whereby request of the petitioners to permit them to visit this aforesaid to visit Mohestola area was turned down on the plea that an order was passed by a concerned by the appropriate authority under 163 of Bharatiya Nagarik Suraksha Samhita. Stop. It needs stop. Petitioner submits that in similar situation, on behalf of the petitioners, it is submitted by Mr. Bhattacharjee, learned senior advocate, that on similar situations previously, this court and the honorable previously coordinate benches and honorable division benches passed order permitting the petitioners to visit the a particular locale with certain restrictions. Stop. It is also submitted that petitioners are ready to go there, less than 5 in number, and complying with the conditions as contained in the order passed under section 163 BNS, which is dated 13 June 2025 by Subdivisional Magistrate Alipur within bracket Sodor, South 24 Parganas. Stop. Next paragraph. Though writ petition does not accompany this order dated 13 June 2025 passed by the Subdivisional Magistrate under section 163 BNSS, but during course of submission, Mr. Dotto, learned Advocate General, and Mr. Bandopadhyay, learned Senior Advocate, representing some of the respondents, have placed the said order before this court for consideration. Next, next paragraph. It is submitted by Mr. Bandopadhyay, learned Senior Advocate, representing respondent number 2 to 5. Representing respondent number 2 to 5, that no specific direction in the no mandamus is required to be issued on this writ petition if order passed under 163 BNSS does not hinder right of the petitioner to visit the locale, then petitioner is at liberty to go there. But no specific protection is required from this court by passing an order on this writ petition. Stop. Next paragraph. It is also submitted by Mr. Dotto. It is also submitted by learned Advocate General, representing state respondents, that in section 163 BNSS, provisions are there to take steps for take steps against order passed by the appropriate authority under section 163 BNSS dated 13 June 2025, and petitioner at leave to take such steps as guaranteed under section 163. Stop. Therefore, no writ petition is required to be instituted, praying for direction upon the concerned police authorities in order to permit the petitioners to visit the locale. Next paragraph. Having considered the respective submissions made on behalf of the parties and perusing the order under section 163 BNSS dated 13 June 2025, it appears that this order that the prohibitory order is existing up to this date, 16 June 2025. Stop. In addition thereto, if court proceeds on the premise that this prohibitory order is still in force, in that event there are certain conditions incorporated in the order dated 13 June 2025, and this court does not find it any impediment in permitting the petitioners to visit the locale in strict compliance with the conditions as contained in the said order dated 13 June 2025. Stop. Having next paragraph, it needs to be recorded herein that in similar situation, honorable division bench passed an order on 23rd April 2025 on an intracourt on a writ petition being WPA 8694 of 2025 within bracket Shubhendu Adhikari and another versus the state of West Bengal and others, giving certain directions. Stop. This court draws inspiration from the said order dated 23rd April 2025 in order to pass order in consideration of the present writ petition. Next paragraph. Having taken into consideration the restrictions claimed in the order dated 13 June 2025 passed under BNSS, court permits the petitioner, both the petitioners along with this one security.
The petitioner number 1 is a Z category protective alert, so they have their own.
Both the petitioners to visit Mohestola and interact with the local persons on 17th June 2025 with prior intimation to the superintendent of police.
My lord, may I, instead of 17 June, my lord, give a 24 hours intimation, my lord,
Yes.
in advance to the SP about the date, my lord. If it is on the 17th or 18th, my lord, I have to take instructions, my lord.
Very well, we will visit on 18th June.
My lord, whenever, my lord, we intend to visit, my lord, 24 hours prior thereto, my lord, we'll.
Today you are interested to go
No, no.
to now it is just
My
my lord, here, no, no.
kindly, my lord,
Your paramount consideration was 60.
my lord, kindly, my lord, give it
You-
some time, my lord, to take instructions about whether it.
Paramount consideration is 16. Now your lordship is allowing not that date. You are bargaining with the dates.
I have to take instructions as to whether, my lord, there is any pre-scheduled.
Pre-schedule, what is this? This is more important than any pre-schedule meetings. You have come to a high court asking to go
Very well, I am permitting to visit within 3 days from date.
within 3 days before giving 24 hours notice.
Intimation. হ্যাঁ কি বলছিলাম সেন্টেন্সটা না within 3 days within 3 days from date with prior intimation to the superintendent of police Diamond Harbour Police District being respondent number 3 and officer in charge Robindranagar Police Station being respondent number 4
Great.
with prior intimation. Stop. Such intimation is required to be submitted before the respondent numbers 3 and 4 24 hours prior to visiting the place by the petitioner.
Extremely great.
Next paragraph. Stop. Petitioner shall follow the conditions as contained in the order dated 13 June 2025 passed under 163 BNS. In addition thereto, both the petitioners both the petitioners are granted leave to interact with the victims at the aforesaid to interact with the local persons at Mohestola. However, they shall not make any public speech that are likely to cause breach of peace during their interaction with the victims,
shall not kick out also the
and also shall not take out any procession.
kick out any process.
আরেকবার পড়ো ঠিক করে দিচ্ছি না সেন্টেন্সটা পড়ো
interact with the local persons and Mohestola. However, they shall not make any public speech that are likely to cause breach of peace
during their interaction with the local persons. Stop. In addition thereto, petitioners shall not organize any procession at the said local during their visit. Stop.
Local and hold any rally or make any public speech. Lots of have given it.
Yes, that I have already stated.
No, kindly one line can you consider
Yes.
that it is earlier that it is expected that jurisdictional SP shall ensure that no breach of peace takes place during such visit and it required additional forces may be deployed to prevent any untoward incident. That is also there in the order.
Stop. Next paragraph. Concerned police authorities are directed to take necessary steps so that no untoward incident take place during the visit of the petitioners and deploy adequate number of police personnel to maintain peace and security at the area.
The loss is disposing. Or no,